So today we just have an awesome privilege. Tim McColly, I've known him for years. He's been my favorite instructor before I even got to meet him for the first time. He's very knowledgeable. I just want to thank Tracy Paris and the staff that has helped her. This project with these listing agreements has been going on since September. There's been so many adjustments and revisions. It's not easy to do this. And so I'm very grateful and thankful for all the effort. We're going to go over these documents, a couple disclaimers and requests. These are not final. They are not on zip forms. We have some time. That's why we're doing this when we're doing it. There will most likely be adjustments to these, so they're not set in stone. Today is to help initiate and allow us to just start to acclimate ourselves to these forms and the changes. Your managerial staff will be here like we are to take calls and all that kind of thing. We are asking that you make notes on your paperwork if you could during it. If you have questions, we're going to do the questions at the end. We're going to try to record this one. I don't know if it'll be the one that they utilize. It's the first one, so obviously there's going to be some maybe little challenges or kinks, and we appreciate your patience. Yes, Brenda. Oh, I gave you a set. Okay. Yes. Okay. I think that should be about all of it. Tim's got some in his office too.
Is this one in order?
I don't know that it is.
Like
Heather, we need
just
one
like a
of
mess.
Yeah,
Oh no, we're gonna need a bunch of them.
yeah, we need a lot.
Now, Kathy had a good idea. Do you want to take the conference room next door and run it on the TV there?
If anybody wants
then
to go
the-
next door, yeah, she's already doing it.
And the materials are uploaded on Connect.
Yeah. That's
So
fine.
let
If
me,
anybody-
this one's a mess.
Okay,
Let me
but
go
in
print
his
off.
desk is the whole set. Okay, thanks, Kyle team. Thanks.
Yeah, so if you guys want to go
Okay,
next door, we're gonna run the same thing. You can always come back and Q&A if you have earth gathering questions. We'll let you do this.
Yeah. And then at the end, like I said, is where we're going to ask questions. So I really want Tim to just be able to get through things, and then we'll do questions at the end.
Tim, this one's only 2 pages. Are you looking for the 17-page packet?
Oh, Tim, you don't have a packet at all.
Packet, I'm gonna go
I've
print.
got my packet, but I don't have any extra.
Okay, who else needs extra?
3, 4, 5, 6, 7. I need to
Okay, some people can share for a minute, right? So that kind of helps. Gina, can you share with one of your voice for a second? Okay, you guys don't have.
Sure. Anyone else? 7, 8, 9, 10, 11. Okay, I'll make.
Okay, she's gonna make packets. We're gonna get started because we gotta get going here. We don't wanna be here all day.
Yeah.
A lot of material to cover. If you don't have a packet, just share with your neighbor until we get them. And, okay, Wendy, we good?
Yeah.
All right. As she said, we're gonna take questions at the end. Obviously, we have a large group. Hey. All right.
Okay, he's gonna try to talk louder.
Again, since we have a large group, we don't want to have questions during. Let's wait till the end and then we'll deal with those. Because we got to get through the contract and the changes that we've made. We got to talk about some of the policy changes that are coming about in August. We'll talk briefly about the July deadline for the state of Indiana. I'll get through the buyer agency agreement and a couple of hints and things that you can talk about with the consumers and go from there. All right. So let's get right into the new listing agreement. And I'm only going to cover the changes. We're obviously not going to read the whole thing. So on the first page, there's no changes there. So if you get to page 2, line 73, seller shall pay in cash to the broker for services, a total commission as follows: $395 plus 3% of the selling exchange contract price with a minimum of $5,000 plus $395, while for sales up to $80,000. So first one, you have 2 choices. We have 3% or 3.6%. That's going to be basically your discretion. We have agents that believe that their services are worth more than 3%. Therefore, you have an alternative 3 or 3.6 or 3.0. I just grabbed the 3.0. The other one would be exactly the same, except it would say 3.6%.
Can everybody hear that? So we're going to have 2 choices. We're going to have a 3.0 and a 3.6. We're patterning after several states, including Wisconsin and some of our partners and leading real estate companies of the world. It's working for them, but you'll have choices again, 3 or 3.6.
All right, then it talks about the minimum commission. And if you can't hear me, just stick your hand up. I'll talk louder. All right, so then we have a minimum commission of $5,000, used to be $3,500 plus $395, the sale price of up to $80,000, less than $80,000. Now, if you want to do the math, you'd say, well, $80,000, we used to have the minimum based upon the full commission. So shouldn't it be less than 5%? I'm sorry, $85,000 minimum on an $80,000 house. Well, there's kind of a thought behind this, and that is that, first of all, how many $80,000 properties are out there? Not a lot. And if you have one, it has problems.
True.
You agree with that?
Yeah.
You're gonna have problems with the property, you're gonna have problems with the title, you're gonna have problems with the owners. And we spend more time solving these problems on a $80,000 house than we do with a $300,000 house. So therefore, we wanted to build in a little extra because we know anticipation of the problems that you incur. All right, good with that. Moving on down to line 97. If it is back up here. So lines 83 through 96. These are dealing with our protection clause. The protection clause is the one that says if the seller sells the property to a buyer that we had interested in the property during the term of our listing for the first 12 months, they still owe us the commission. So that's been a protection clause. He's already had that in the contract. It does break it down into two areas. If it is a residential property, 1 to 4 unit residential property, and they have listed the property after our listing has expired, they've listed exclusively with another company, and that buyer buys, well, then we are not entitled to a commission. If it is a commercial property, more than 1 to 4 family residential, then the extension clause is not canceled. That extension clause stays in effect for 12 months after the expiration, even if they relisted it with another company. So it gives you, the language says you better make sure that the other company understands that. So if it sells within 12 months after the expiration of our listing to a buyer that we had caused to be interested in the property, they still owe us the full commission. Other language, lease, though we normally get 1 month's lease with a minimum of $1,000. Okay. Next one. Line 97, then, of course, land contract says that they will get 3% of the purchase price at the time they enter into the land contract. Line 100 talks about buy-side commission. So this is where we are suggesting to a seller that they still consider offering potential compensation to a cooperating broker and to other McColly agents. So all other participating brokers' compensation to others will pay 3%, or whatever percent they put in there, which could be 0. That's something you have to discuss with the seller. Because what are your sellers hearing out there today? Oh, we don't have to pay a buyer agency anymore. We're going to save all this money. And I cringe when I hear these statements being put out by some national organizations who don't really understand how, in fact, the real estate transaction works. And AARP, for example, maybe you've heard this one, is telling their elderly members how many thousands of dollars they're going to save in the sale of their property because they don't have to pay the buyer's agent anymore. Well, anyway, so again, we're suggesting maybe 3%, maybe it's 2.5%, or again, could be 0. And we'll discuss why that could be. Also, we're suggesting that as far as other McColly agents, if a McColly agent brings the buyer to our listing, we're going to offer them 3% compensation. Again, sometimes you're going to have to adjust. Yeah. But let's start, and this is what we're looking for. Go from there. Then it talks about buy-side considerations. All prices and commissions are negotiable, satisfies our antitrust language. The amount of compensation indicated above is consistent with what we charge for our buyer agency services. And then goes on to talk about the benefit to the seller. They're going to be working with a buyer's agent. And bottom line, taking money directly from the buyer, which would lower the amount of money they have for a down payment, which could lower their borrowing power, thus lowering what they could actually pay for the property. We'll get into that more towards the end of the program. But that's why there is a benefit. Put it simply, can the seller pay the buyer's down payment?
No, I said
No.
that yesterday at the managers meeting.
Really? Yes, you can, as long as you don't call it paying the buyer's down payment.
Gotta call it the right thing.
So you pay a bunch of other money to the buyer for other stuff that they can use for the down payment. Well, to me, that's kind of like paying their down payment. We just can't call it that.
Right.
All right, and we'll get more into that later. So anyway, we are suggesting to the seller that, yes, you offer some buy-side consideration. Again, this is not something you want to lose a listing over. Again, we're suggesting to the seller, but bottom line, we need to get it listed. And we can deal with any other issues as we get down the road. All right, next page, on line 130. Earnest money dispute. So obviously the earnest money paragraph stayed the same with the exception of the last sentence, which says in the event of a dispute with respect to the intended disposition of funds in escrow, then at our discretion, if we so desire, we can deposit the money less any costs with the clerk of the circuit court. We don't have to, we could. And if you're not aware of this, we do not use the 60-day earnest money release process. There's just too much risk involved because the state says we can do that, but the other guy's attorney says, no, you can't. And so we kind of learned our lesson that once we start making the determination to the 60-day release process, who gets the money, the other side's not going to be happy, and then we're dealing with other problems. So we want them to work it out, and if necessary, we can deposit it with the court. No other changes on that page. So when we get to page, no changes on page 4. No changes on page 5, with the exception under the home warranty coverage, we have removed the auction option since we have not been doing that. So that's out of there. So then we get to page 6, line 342 through 351, we talk about dispute resolution. Basically, that says that to avoid extensive litigation, the parties agree that in the case of a dispute, we will use arbitration. Through the American Arbitration Association, the hearing would be held here at the corporate office, and the parties are agreeing to waive any rights to a jury trial.
And Tim, to reiterate from yesterday, we're talking listing contract now. This isn't purchase. This isn't with a buyer.
This is not between the buyer and the seller. This would be between our seller and us.
This is if
If there is a
McColly.
dispute,
Yeah.
Again, with our seller client, then that's the way we do it. Again, this has no effect on the purchase agreement between the buyer and the seller or what their rights would be. On line 365, unless otherwise noted, McColly Realtors will publish the MLS listing within 72 hours of the effective date. General. All right, so this is general legal language. All parties, indemnities, limitations, blah, 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 binding on their heirs, successors, assignments, so forth. This agreement, except as it tells you in paragraph 2, starting ending dates cannot be amended without the agreement of all parties. Goes on to say that you can have multiple counterparts, but it's all one contract. So if I send it to one seller here, one seller here, one seller here, it's still all one contract. And other than that, nothing out of the ordinary. And then you have your signature page. But you also have another page separate. It says line 6 or pages 6 and 7. Front and back. The new page, because after we did this at the managers meeting, there was a recommendation, so this is kind of hot off the presses. So it's a separate page that would have been added in addition to the rest of the packet. So it's one page, front and back. Line, page 6 of the listing agreement, page 7. And on line 367, that's where we reinserted that the effective date of this agreement shall be, and you put in the effective date there. All right, hold up. On this page, it will have on line 368 or 69, we have reinserted that the effective date of this agreement will be, and that's where you put in the effective date. And then on the back page, where it says effective date, the new one just says date. Because otherwise, we're getting confused here. What's the effective date? Is the effective date when the manager signs it or whatever? No, let's move it back to page 6. So we are specifically telling the seller that the effective date will be. Because remember, all right, so remember the use of the effective date as opposed to the marketing of the sales and sales marketing agreement. So the effective date is the date from which we have to start measuring when it has to go into the MLS. So you have the seller who says, well, I want to paint the bedroom and I got to clean out the basement. So we want to get it listed now and get the contract in place, but we're not going to start it for 10 days. So we can make the effective date 10 days down the road. We can't do any marketing to the public because that rule says we got to put it in the MLS within 1 business day. But we can get it under contract. We can do our internal marketing, put it on coming to market, talk about it within the company. But again, the effective date doesn't start until 10 days down the road. And within 72 hours of that date is when it has to go into the MLS. All right. So, questions?
Is there a max float for that date?
Is there a max float? How far down the road? Nope.
Have the commercial forms been amended accordingly?
No. There was some question, and Jeff was at the meeting yesterday, that is this going to be the commercial form? But he said, no, there are some other things that if you wanted this to be one form that could be used both by the commercial division and the residential situations, there's got to be some better language about leasing and other things. So no, this will not be final one for the commercial department. Question?
Was put to be determined as the effective date?
No. And not have an open-ended effective date.
Because we can amend.
Tina?
Is this any question, Tim? I just have the commission question.
Sure.
You mentioned it can be 3 or 3.6. Can it be anything in between, like a 3.5 if we were used to that?
All right. And I think somebody else said, well, what about we do with builders and flat fees and so forth? So it's like everything else. There's obviously times when we're going to have to negotiate. But just from a negotiating standpoint, the fewer options you give the other party, the less likely they're going to ask a question. But if we have to change something, for example, for a builder, then we might be charging a flat fee, then you put see further conditions, and then you would spell out what that would be. If you, again, believe it's something other than 3 or 3.6, well, then you could amend the contract with them, have people initial it. And again, towards the end under general, I mean, there's a limit as to how much we can allow you to amend the contract. I mean, you come in, this seller was really tough, so I only got 1%. No, we can't be doing that. So there's got to be some limits.
I'm saying between the 3 and 3.6. That's okay. If
Okay.
you just do a 3.5, for example.
I wouldn't have a problem with
Yeah,
that.
you could, Tina. Yes, you could. Again, what we're thinking is we are going to be retraining people's minds, their way of doing business, their thinking patterns. So to just keep it concise, but yes, you could. Remember though, and again, deception, not from an authoritative standpoint, but I'm going to need to, any manager, not just me, is going to need to sign every one of these things. Every time there's a listing amendment, you need to get it to me for signature electronically. I will sign it as quickly as possible. Anytime there is an amendment to the buyer's exclusive agency agreement, it has to be amended. You can't just, decide, oh, to make this one deal work, we're going to go down to 1.5. If our buyer's exclusive agency agreement said something different, we have to amend. So just keep in mind what the differences are going to be. Communication with the other agents to resolve some of these things so that you're not spending as much time on all the paperwork. So these are just the things, we're gonna have more meetings, but this one is just to get us started in how to approach and what, that kind of thing. So go ahead, Jen, you were the next one.
The current contract that we have now, are they like void July 1st? Or do we have to rewrite contract?
No,
Rewrite?
this is the listing agreement, July 1st. The only requirement is for the state of Indiana, you're going to have a written buyer agency agreement. But that's for the state of Indiana. And I haven't seen the entire law yet, but I've been told it's very vague. It just basically says, yeah, you got to have a buyer agency agreement. It doesn't say when it has to be signed or anything else. But the big one is going to be August 17th, because that's when the NAR regulations kick in. And that's what we're going to be talking about once we get done with any questions on the listing agreement. But any current listing agreement, no, does not have to be changed, but just as we move forward. And as far as zip forms, we're not talking about having that zip forms 3 months from now. Their original date was the 18th, which is only a week away. So basically, they're still shooting for a date in the very near future to have it on zip forms. Again, we're making a couple changes as we did at the managers meeting yesterday.
Just real quickly, because I have a seller that mentioned this to me already. He said he was only going to do a flat fee for buyer commission. Would that go into conditions?
For the buyer commission. Yes, if that's what he's saying at time of listing, we can put that under further conditions. So buy side consideration, see further conditions.
Again, okay, go ahead.
Yeah.
Oh, that's okay. Bart was first. Go ahead, Bart.
And maybe I missed something with the other, the extra piece of paper,
Uh-huh.
but, so we have a section where it says, when we're putting it on to the multiple with the MLS, and they're initialing, and then we're saying, if not within 72 hours, they put into MLS, and then an effective date for the contract.
Well, that was the confusing part. So where it says effective date, move it back one page. And then the part that says we're going to put it in within 72 hours or,
Oh, okay,
then the new one says, here's the effective date.
Thank you, Bart. We
And
didn't
on the
make that clear.
back, that's the date that is
Yeah.
signed.
That was confusing yesterday at the managers meeting, so there might even be, that's one of the areas that might even be tweaked further, but like Tim just said, that's why he did the extra page for us this morning. Okay, Dan, and then Tracy, and then we're gonna move on. And we'll do comments.
All right, page 2, line 104. It is required the seller to pay 2% of the county agent that they provide.
Correct. And what we are trying to do is solidify compensation for McColly agents that the buyer says to encourage our agents, obviously, and in any real estate transaction, there are what are called transactional costs. Both the seller and the buyer have transactional costs, and buyer agency services are a transactional cost. And again, we're just trying to give some support to McColly agents that the seller agrees that they will pay McColly agents that bring the buyer a 3% buyer agency compensation. So even if they said, I'm not offering anything in the MLS, that's a 0 on that line. Okay. Well, we'd still like to encourage cooperation within our company, and we're trying to give you some level of protection there.
What if they get multiple offers and they ask you if one from a retaliation?
That's what we deal with. We have to deal with. I mean, we can't anticipate every problem.
Again, a lot of this is to get the communication going, because part of the reason that all these suits started is that we did not, when I say we, the country agents did not make it, very relevant and very understandable to clients that they don't have to pay what they paid. So now we have to back it up And now we're going to have to go overboard in some instances. The key is that we're calling it participation. I think Tracy said again yesterday.
Participating broker, that's one of the changes.
Participating broker instead of co-op broker. If you could get that language. And then there's just, everything is negotiable. I mean, to a certain extent, again, I can't have you represent a buyer for 0.5% or 1%, but I think you know what I mean. Things are negotiable, Dan. So even in that instance, if your seller said 3 and it's on the market to McColly and it's on the market for 150 days and it's 30,000 less than what he anticipated, even though you told him it wasn't worth that much, at the end of the day, there's still going to be negotiation going on. You know what I mean? We're not going to go down to 1% for the McColly agent for something silly, but there's going to be some negotiation. The key to this is because as a managing broker, I get complaints. Your agent never showed the property. Why didn't you have McColly agents showing the property? So we are needing to let people know we are trying to have McColly agents show the property. That's why we need to try to use Connect and do all these different things so that it fosters the network that we do have. We're fortunate to have this many agents, and you all work very well together. And our public needs to know that, because it's not the case in all brokerages.
And not to get ahead of myself, but from the point going forward after August 17th, you, the buyer's agent, need to be protecting yourself. That's the purpose of the buyer agency agreement. So the fact that the seller says, I don't care, I don't have to pay anybody. Okay. But that doesn't mean that the buyer might not ask you to participate in some of their transactional costs. One of those costs could be a buyer agency fee. But just like any other purchase agreement, when we see it, then we can see what we're dealing with. I'm just telling you, even though you are suggesting we're not paying a buyer agency fee, I got to present any offer by law. If they ask for it, well, then we'll have to deal with and see what we want to do at that time.
Mm-hmm.
So we'll get more into that when we get into the buyer agency.
Going back to that, so as a McColly agent, if you have another McColly agent on the other side, and say we have a 3% listing commission agreed upon, and say they don't want to pay the buyer agency, do we still have to split that 3%?
No.
No, 3 is the listing. 3 or 3.6 is listing. That's all we're talking about. All that's other. So keep in mind, like what Tim said is, this is why the buyer's exclusive agency is going to be, like Tim said, it's vague right now. If Dawn has a property and I'm not with McColly Real Estate, I don't have to show her my buyer's exclusive agency agreement. They haven't said that's law, but she's going to know if I have one or not, right? Because when I bring an offer, if I'm not covered, we got a problem. Because if her seller wasn't anticipating to do much, even though it's still negotiable, there's going to be problems. So at the end of the day, like Tim said, the buyer's exclusive agency agreement is for your protection. We don't want to work, we can't work for free, and we don't want to work for 2 cents. So we need to have it in place, but that's when you're going to know, because when you bring that buyer's exclusive agency agreement. And just real quick back to, I think, Brenda's flat fee. At the end of the day, with listings being on the market longer, some at least that I'm seeing, you are going to limit your buyer pool even more. If you say 0 or flat, and you've got an FHA or VA buyer, they're going to most likely have to ask for some closing costs and potentially some the buyer's exclusive agency fee. So it just, it's like Tim said, each thing's going to be negotiable, and some of these things we're going to have to work out. We're trying to plant the seeds in our seller's mind that they begin to understand, yes, the ship is turned, and we're all kind of going through this together.
So we have to walk the client through the logic of who can afford to pay his buyer side.
Yeah, and we'll get more into that when we get into the buyer agency agreement. Lynn?
I haven't really taken the time, to be fair, to wrap my head around any of this yet. But before, how we had to disclose like variable rate commissions and things like that all goes away.
Correct. Because we're not going to be, because on the MLS required that you have to disclose that.
But see, it's not going to be disclosed, Lynn, as of August 17th or sooner, right?
As far as I know, August 17th.
There will be no posted, nothing. So nobody would know if you had a variable rate except for your listing.
The big thing is.
That was a no-no before, but now it's okay. Like, we're going all the way back.
Correct. Because again, the buyer agent should have an agreement with their buyer as to what their compensation will be. And it's up to the buyer agent then to ultimately determine how we can get that fee paid. And so a big thing with this settlement policy changes is that there's no mention of buyer agency fees on the MLS. So whether it's a variable rate commission or anything like that, got nothing to do with it. Question?
Okay, one more, then Lisa, then we need to keep going. Who,
So when we have a PA that we're sending to the seller, we're attaching this exclusive.
No.
no, we'll get, aren't you gonna get to that in a few
Yes.
minutes? Okay, we'll get right back to that. Lisa, with your,
Just had a question. If, just because we are explaining this to, on the listing side, if they say, you know, I don't want to pay any, buyer's commission, and I'm certainly not paying McColly, a McColly agent 3%. They're not liable to pay that. Is this just a suggestion?
Well, it's a contract, so you'd have to amend the contract.
Correct.
So if you had to put 0% on the first line, and then if you had to line through the part about the McColly agent, have them initial,
But, and that would be acceptable for our office.
not preferable, but acceptable.
Not preferable, but acceptable.
as long as, we'll say, just a second, as long as you, and you know, but have had the discussion with them, that they're most likely gonna end up paying somehow. They can, in their mind, think they pay no commission, but then they're gonna have somebody else for 3% closing cost.
Yeah.
Okay, so, you know,
We
you
just don't
know
want
what you
them,
mean.
I just don't want them to feel like we're pressuring with the McColly.
Again, we're not trying to give this be a reason why you wouldn't get the listing.
No,
This
no.
is a suggestion as far as compensation we are still offering, but you're protecting yourself on the listing because again, other agents are protecting themselves with their buyer agency agreement. It's not my job to protect them. I'm trying to help them, but it's not my job to protect them.
See, when you think of it that way, it's gonna take some pressure off of you. I know a lot of you have been pressured. You are the, in this case, you're the listing agent. You are working on behalf of your seller. You're gonna educate them, but until that buyer's offer is brought, you don't know what you're presenting. It's like anything else. We don't know until we know. We tell a seller what we think we're gonna get. When I do my net sheets in this market we've been in, I add everything, survey, warrant, closing cost contribution, everything. I pad it. So you're gonna do that on your net sheets. At least I'm gonna do it. You can do what you want, but it would be the wise thing to do. To talk about these things, and that's going to be the excellent time to go over it further on the net sheet. Anticipate, even if in Lisa's case where if her seller said, nope, 0. Okay, just what if we get the pristine offer and we've got to give something? Okay, 2% maybe, can we put that in there? And you'll put that in. To just, again, they're not saying they're going to do that, but they're signing it to say what you discussed it with them. Okay, so we had Ed, Jeff, and then Tracy, and then we got to keep moving on. Ed.
We're gonna have more meetings about this, or is this the?
Well,
only
the
meeting?
bad news is,
I didn't hear this. I'm gonna say this.
I knew this was happening, so there's nothing we can do about it. And then ironically, I got a call before this meeting from one of my other agents who's involved with the MLS and said, oh, they have a new buyer agency agreement.
Mhm.
I said, I don't think they have a new buyer agency agreement, but they are working on one.
Mhm.
But they said they'll have it before July. So I knew that there was gonna have to be changes to our buyer agency agreement.
This is practice. You
But-
said it, Mike.
Again, it's probably gonna be changed something from what it is, but I don't anticipate that there's gonna be a whole bunch of different issues that we're not gonna talk about this morning.
Yeah.
So,
And Ed, yes, and the offices I oversee, we're going to have another meeting before July 1st. So I don't know the date yet. Jeff.
okay,
So closing cost compensation by the seller, can those be used to pay the commission then?
those can be used to pay the commission, and if you're not aware of this, Fannie and Freddie both have come out and said that any concessions to the buyer any concessions from the seller to the buyer for closing costs associated with financing, any buyer agency fee paid by the seller will not reduce the concessions available to the buyer.
That's huge. Mhm.
And VA says we will also do that until we have our final determination.
Tammy, real quick.
Just real quick, is there anywhere legally so we have a seller and we can talk them into offering a 3% commission to anyone, we agree to that. Is there anywhere where, I know we can't in the MLS, we are legally can advertise that I have a listing, and they will pay a buyer agency?
Well, that's a problem. The problem is, how do you disclose it? We'll get into that under these practice changes.
Because Ron's understanding as far as nowhere, but like Tim said, maybe that'll change.
All right. So again, we still have questions. We'll get to the end, or I'll stick around to answer those questions for you, but we got to get going on the rest of our stuff here. So the next page in your packet is now member practice changes effective August 17, 2024. I'm not going to get into all the lawsuits and all the settlements and all this stuff. And I just read again this morning, there are appeals, a couple of appeals to parts of this settlement, because there are buyers that are saying, hey, I didn't get my day in court. I want my chance to get some money too. Or more money than I might get out of this settlement. So, but we're not anticipating that these policy changes or practice changes won't go into effect. So here's the basic crux of this whole thing. The lawsuits were based upon what? That we as an industry are artificially inflating compensation to the seller to pay buyer agency fees. When in fact, the buyer agent who's getting services from their perspective should be paying their own fee. And therefore, that's how you collude and conspire against the sellers. And it didn't take a jury too long to agree with them, to the tune of $1.7 billion, which when trebled because it's antitrust, quickly got to $5 billion. And then there were another couple dozen lawsuits filed after that. So yeah, they try to get this whole thing together, come up with a settlement to the tune of billions of dollars to kind of end all of this. But again, maybe it hasn't ended. But anyway, here's what they said has to change. First of all, eliminate and prohibit mandatory offers of compensation through an MLS. So the MLS cannot be the conduit from which you will make buyer agents aware of any compensation. MLS can't say anything about that, which we just talked about. Second one, prohibit the making of offers of compensation on an MLS. Third one, require all compensation appeals be eliminated. Okay. Next one, eliminate, prohibit, rule requiring or accepting an offer of compensation as part of a cooperative agreement. Next one, agree not to facilitate offers of compensation on any non-MLS mechanism, like a third-party website. So the question about, can we still advertise? No, really. The only thing that we are aware that you should still be able to do is internally. Because if I could tell you, a McColly agent, that my seller is willing to offer buyer agency compensation because it's within the company. But once we start talking to other companies or putting something that might be available to the public, no. So again, if it's done internally, if it's done on our intranet, so far, I'm sorry?
Another broker calls you and asks you, are you
It's
offering
okay.
compensation?
That's okay. So if
So
you
far.
do have,
Unless there's a change.
yes, if you do have a seller that will say, yeah, I'll still offer some compensation, you could directly tell other agents, at least at this point. So the idea being, there's a showing schedule, you call that agent and say, just want to let you know, and maybe you tell them the amount, maybe you just tell them that my seller has indicated they're open to paying buyer agency compensation. But from a practical standpoint, you, the agent, and here's what I'm telling people, you have a buyer agency agreement. You just assume that any house your buyer wants to buy, that seller will pay compensation. Make that assumption. Don't, well, how will I know if they're offering to pay anything? You probably won't.
You may not know.
I'll give you a quick example before we move on. How many of you have had buyers that their lender says, make sure you build in $4,000 for closing costs in the prepay? Happens all the time, right? And who says they have to do that?
They don't.
Their lender. So do you check every listing you show to see if the seller is offering financing concession? No. What do? I make the assumption that if they want this buyer to buy their house, they're going to have to pay closing costs. It's no different here. So just keep that in mind.
Keith,
All right.
and your question, other people aren't going to see. If you have a listing contract, Jeff Hill's not going to see your listing contract. So he's not going to know.
Isn't it built in that if we list, that a McColly agent participates, that they get 3% on the buyer's side?
It's
So do
on
we
there,
have to tell everybody
Possibly.
but it may not be.
if it got negotiated otherwise?
So it's not an automatic.
Then we would,
And
Can I advertise, newly remodeled $300,000 house, 2 bedrooms, 6 bathrooms. Seller is very liberal with closing costs.
He said that was planned.
All right. To the best of my knowledge, as long as I do not reference buyer agency fees,
Yeah, can't talk about commission on social media.
yeah,
Thanks.
We really gotta
Can
get.
we say on Macaulay Connect?
yes, at this point, yes.
At this moment, that
And
might
then we can
change.
share that on our social media.
No.
No,
I think if we got something on Macaulay Connect, or we got it on our web, we put it on our webpage.
no. I mean, it could get as, but some things aren't negotiable. What I was talking about is the contract. This is not negotiable that you, after that, on August 17th, I don't even know what the fines are gonna be yet. Some of that they haven't told us, have they, Tim?
No. But the general rule is, can the public see it in some way?
No.
Well, generally, can anybody go to your website?
Yes,
Well, the public could see it, so you can't do that.
that's why we can't do it,
Well,
because
it's only
anybody can go.
my social media. Well, is everyone on your social media Macaulay agent, or do you have others?
Others.
Well, you're gonna have others. If you just have Macaulay agents, you need to get another license, but that's a different point. So if the public might see it, or another broker might see it, no. Again, I can tell them directly, but I cannot just put it out there. All right.
Real quick, Sue Blue.
Tim, if you, just in a nutshell, so we go on a listing appointment and the seller says, what exactly happened with this? Why did this happen? Can you give us like, what would you say? Because, I mean, how are you gonna explain what NAR did?
Can we wait till we get into buyer agency?
Yep.
Because we.
Thank you. Good
In a
point.
nutshell.
Good
All right.
point. We'll just give you a snippet.
All right. So if there is an agreement that is going to pay compensation, I'm sorry, back that up. Require written buyer agreement before a buyer tours any property. So in many other states that have already required buyer agency agreements, generally the recommendation was you have them sign it early in the relationship. Many of them, though, didn't have the buyer actually sign the buyer agency agreement until they submitted an offer to purchase. But that, under the NAR rules, says nope. Before you tour a property with the buyer, you need to have a written agreement with that buyer, specifically disclosing how the rate or any amount of compensation is going to be calculated. It has to be objective and ascertainable, not some open-ended thing. Or prohibit receiving any more than what is in the agreement. So you have a buyer agency agreement and a seller is offering more than your buyer agency agreement. Well, sorry, you are limited to what was in the buyer agency agreement. Well, how about if I just amend the buyer agency agreement? Okay, technically at this point, we don't know that you can't do that, but I don't think that that's gonna undergo scrutiny if you're just using this as a way again to circumvent what the heck they're trying to accomplish by specifically telling the buyer what compensation they are responsible for.
Plus timing's gonna be a big issue. If, you know what I mean? This can only happen,
Can't you say a minimum?
No,
No.
because that is not closed-ended.
so.
Could be more, but you can't, that's not ascertainable.
So what he's saying is if I have a listing and my seller was willing to pay 3%, and ABC Real Estate brings me a contract and they would only have 2.5 on their buyer's exclusive agency agreement, my seller does not have to pay them 3, nor do I get the extra, or Macaulay.
I think he does. He has to pay you 2.5, the other 0.5 has to go to the buyer, as I read it. So that
That's not what we
compensation, if it's
To the
offered,
buyer.
that excess money goes to the buyer of the property.
The purpose of basically stating that you get what you agreed the buyer is responsible for. Because anything over and above that should go to the buyer. That's
To the buyer, forgive me, Jeff, not the buyer's broker.
not the buyer's
Doesn't
broker,
get it.
to
If
the
they only
buyer.
Yeah, so if
put
it's
2.5.
3% and you have 2% on your 2.5% on your buyer's agency,
Mhm.
you get the 2.5, your buyer gets the 0.5% extra.
Gets the extra, but not the buyer's agent.
Could you do a flash fee?
Flat fee for what?
Services.
Well, again, whatever you agree to with your buyer client, and we'll get to that. All right.
Okay, let's go a little bit further. We've only got so much time. Go ahead, Tim.
All right, prohibit any representation that your services are free. Any offers of compensation from the seller must be in writing presented before any actual payment of compensation. Any agreement must specify in writing that commission rates are not set by law, negotiable, and no filters on the MLS based upon the offer of compensation. Other clarifications, one is working with me. That means an MLS participant, a participating broker. Again, we're eliminating cooperating broker. It's replaced by participating broker. You are providing brokerage services to the buyer, showing them properties, sending them properties, talking about problems, whatever you're doing with your brokerage services, you are then working with them.
Do we collect upfront for our services?
Well, we'll worry about that one later. This does not include an MLS participant who's simply talking with the buyer, like at an open house, or providing access to a listing to an unrepresented buyer. So if you're the listing agent and a buyer calls you, or you're holding an open house on your listing and a buyer comes through, well, technically, you are holding an open house as a service to your seller client. So I do not have to have a written agreement with any buyers that come into my open house. Unless, of course, I start providing brokerage services to the buyer. Next one. MLS participant is working with an agent as an agent or sub-agent of the seller. But again, in Indiana, we don't have sub-agency anymore, so that's not an option. But again, if I'm just providing seller services, and it includes having conversations with buyers, I do not have to have a written agreement with the buyer. And limited agents, because a limited agent is representing both, which includes the buyer, you would have to have a written agreement. Further clarifications, touring a home literally means entering the property with the buyer for whom you're providing services, or even doing a virtual tour for them. And we're talking about 1 to 4 unit residential properties. A written agreement does not have to be an agency agreement. So again, we're going to clarification on that one, because in Indiana right now, the only buyer agency agreement we have is an exclusive agency agreement. And when I saw that, I said, I know that there's going to have to be some other considerations here.
Because
So
you've
we'll see
seen in
about that.
Illinois, there's already two. There's two different ones in Illinois for you Illinois.
Then it talks about hosting an open house, and one of the pages you have in the handouts, which we won't go over, is your disclosure of non-agency. So it's recommended that if you are talking to a buyer, like in an open house, just so there's no confusion, you have them sign this form that says, hey, you understand I'm not your agent at this point anyway. Again, MLS participants may not receive compensation from any source that exceeds those agreed to in the written agreement with the buyer. Again, August 17th. Any current buyer agreements that do not meet the new changes as of August 17th, and that buyer is not under contract in an accepted purchase agreement, then you should amend your buyer agreement to conform. Any current buyer agreements that are there, but we have an accepted offer, then we don't have to worry about amending it, nor do we have to worry about receiving the compensation that was agreed to per the listing contract from that seller. In other words, on August 17th, the seller can say, that deal, I don't have to pay them anymore. No, that is already in contract and good to go. And therefore, offer to purchase has not been accepted by the date the MLS implements the rule. To my knowledge, NYRA is not going to be instituting the rule any earlier than August 17th. And if somebody knows different, I haven't heard it. And again, Indiana enacted legislation that's going into effect on July 1st. But again, it's just saying that you have to have a buyer agency agreement. So the big one is NAR. And that's not the law. That is the rules under which NAR participants have to play. And since we belong to the National Association of Realtors and the state and local association, if NAR says this is what you got to do, that's what you got to do. So let's take a look at the buyer agency contract. And the reality is the only page we have to, I gave you the whole contract, but the first page is the one that counts. The second, third, and fourth page pretty much are just right out of license law, defining what an agency relationship is, talks about limited agency, blah, blah, blah. So the first one, Contract is entered into and shall commence on, so here's the beginning date of the contract, just like the beginning date of a listing agreement. Here's the broker company, and here's the buyer names. Buyer employs the broker for the purpose of exclusively assisting the buyer to locate property, and this contract shall terminate on midnight on. Okay, so people ask, how long is this going to be? And my answer to that is, I don't know.
As long as you can get it.
Well, that could be a good answer as long as you can get it. But here's the deal. You have a buyer you have never met before. You don't know them from Adam. They saw your sign and your name rider. They call you and say, we'd like to look at this property. All right. Since it's my listing, I have to inform them, okay, this is my listing. And I presume you are not being represented by a buyer's agent. And I could provide you access to the property. Now, at this point, you don't have anything from the buyer that says they will pay you. All right, so we have to deal with that one. But you say, well, before I can show you the house, I'm going to have you sign my exclusive buyer agency agreement. They say, well, what does that mean? Well, for the period of time we agree upon, you can't buy a house from anybody else except me. And if you do, you still got big. You think you might have some buyers that might be a little reluctant on that? Now, you have past clients. Every time they're interested in property, they come to you, right, Wendy? You have those. And they're fine. So, if the right property comes up, let me know. We're looking for an investment property, whatever. And you say, okay, but we do have to have a written agreement. And I know that you've been loyal to me and I certainly appreciate it. And you know the services I provide. So I'm just going to put a year. Sure, fine. We're not going anywhere else. So it depends upon the situation, which you'll kind of have to evaluate. Maybe it's a week. How about if we do this? Well, let's make it for 7 days. I will show you some of the services I will provide and the things that are going to be available to you. And then at the end of the week, we can reevaluate if we want to see if we fit together and we want to extend it. So it's not going to be like a listing contract where we say a year. And why do we need a year contract when houses are selling in 3 weeks?
Taking multiple times to sell some houses.
Because not every house sells in 3 weeks. And there's a house in my subdivision that just went under contract. It's only been on the market for 15 months.
Oh my God.
And when it came on the market, I looked and said, I know crazy, but that's beyond crazy, the price that they are asking. I says, that ain't never going to happen. And guess what? It never happened. And it went from over 600,000 down to 470. Well, they finally have a accepted agreement. It hasn't closed yet. So why do I need a year listing? Because sometimes it takes me a lot of time to educate the seller as to the realities of the marketplace. I certainly don't want it to take a year. I want it to be normal. And I want them to be competitive. And I wanted to attract an offer in the first 30 days at least. So that's all we're saying. It's gonna, maybe you're gonna have to have some flexibility. Ken?
Yeah, just something, this is not so much a cool question as a clarification. You and I, we have taught our students that obviously you cannot poach other people's listings. I would say that this also says that if somebody calls you asking you to represent them as a buyer, you should probably now have your antenna up, or do you have any exclusive agency with anybody else?
Okay, Code of Ethics says what? That you cannot infringe on any exclusive agency agreement a person has with their
It's also
broker.
state law.
Correct. And so therefore, you need to ask people up front, have you signed an exclusive agreement with any other agency? And this would still be the case. Just like when you go on a listing, you haven't listed the property to anybody else.
Right.
Well, I'm going to ask the buyer the same thing.
Now, what if this becomes a situation where it's going into a dual agency? So say, for example, I got a property, the guy comes up, says, I don't have an agent, can you show me the property?
All right, then I've got to get him to agree to a buyer agency agreement, and it talks about limited agency.
In Indiana, limited, so that's kind of what he was
So I'm representing the buyer, so I got to have a buyer agency agreement,
You'd have to have that.
a buyer agreement.
For every phone call I get on Joe Blows.
Well, if they want you, if they agree that you are going to represent them and provide buyer agency services, you need a written agreement.
So again, the question just isn't what we've lived with for years. Are you working with an agent? Have you signed a written buyer's exclusive agency agreement? If they lie to you about that, we've got a different problem and we'll have to work that out. But if they haven't, then you would have to have them sign that in order to show them the property and bring the offer if you are limited in Indiana.
If I'm not bringing them any offers, so then basically.
But you'd still want them to sign it if you're gonna show them other houses, right? Yeah. The key is if they're just using you to show them a house quick because their agent's on vacation, if you ask him, have you signed one of these? And they say, yeah, I am working with somebody for another 3 months, then he shouldn't show the house, right, Tim?
Correct.
You can't show it. Somebody else has them. They're gonna have to just wait a minute or get a co-agent in their office that will pay or something, or yeah, to show it. If they have signed one with someone else, then you're not gonna be a limited agent in that transaction for at least the time that they're good on their buyer's exclusive agency agreement with the other buyer, buyer's agent. Does that make sense?
It does.
We think there's, yeah, we can talk to it further.
Should we, address the possibility of limited agency within the listing contract?
The listing contract already addresses
It already-
limited agency, and your buyer agency agreement on page 2 or 3 addresses limited agency.
Some of those things haven't changed. We've patterned that stuff. We've kept it to the same form. So good question, but yes, it's on there and you have to discuss it on the listing contract.
Okay, well, what happens when the seller lies to you?
Probably court.
I'm just saying, when they lie to you, well, we have to deal with that problem because, well, we'll deal with that later, because if they lied to me, they could still be liable for their fee. Well, if I have a written agreement that says if they buy something, I'm entitled to be paid, then I have a written agreement that says I have the right to be paid. I don't really care that they lied to me. That was their problem.
So if we get this buyer's agency contract signed, does this protect us as agents when they go into a Lennar open house or?
The
when they
question, does this protect us that walk into an open house? Yeah, because this says for the purpose of exclusively assisting the buyer to locate property below. So that's
This is
the
why
deal.
Ron says he thinks that, Mr. McColly's saying he thinks there will be ways we're gonna make more money, everybody. There's gonna be instances where we haven't been paid or we've lost out. That's a perfect example that we will now be paid. Go ahead, Jeff.
So you don't have to register your, buyers with.
Not saying that. I'm
We're not saying that. You should still register them and do that. We're just saying, but what if? Well, the what if is if they said, no, we're not even interested in new construction. And they walk in to a Lennar open house and they end up buying it. And I didn't register them because they said there's no point. Well, I still have some protection.
I have two questions. First of all, can you, say you sign a buyer's agency agreement at 3.5%, can you reduce that prior to the closing? Like if the seller's offering a 2.5% compensation?
Any contract can be negotiated. And
Reason
any
being
contract
is
can be altered. It can be amended. Have you ever worked out a deal where the seller said, I'll pay this, but now we're $1,000 apart, so both parties agree to take less?
Yeah, the reason
Same
being is
difference.
like a lot of the production builders will offer at 3.5 or sometimes up to 5% compensation. So you're gonna be leaving that all on the table if you don't make that change to that agreement. My next question is, on our listing agreements, we're covered by, like, say in a buyer's agency agreement that they sign with us and it expires in 3 months. What if we've shown them, we're gonna go buy a house, we show them?
It's covered down on lines 27 to 28. So, all right, moving
Okay,
right
good
along.
question.
Let's try to get through this
Yeah,
and then we'll
let's
come
get through
back to any
this and then
questions.
we'll have a few questions
All right.
again.
So again, how long? We don't know. So again, you're gonna have to kind of play it by ear as to what your relationship is. The broker agrees to diligently locate the property. Okay. The description, kind of what are they looking for? They're looking for 4 bedrooms and at least 2.5 baths and at least a 2.5 car garage. And it's a ranch or 2 stories. Okay. So it's just in general, you know, don't tell me you're looking for a 1-bedroom condo, but then you buy a 4-bedroom 2-story. So just broker's compensation, retainer fee, in all likelihood, you're not getting a retainer. I know in commercial real estate, they sometimes do that, but they're probably not getting any money up front from the buyer which is non-refundable because at the end of the agreement, if we haven't found something, I get to keep the money. Probably not going to happen. Here's the commission. They'll pay the commission of whatever the dollar amount or a percentage of the total purchase price. And here's the important part. End of line 21. In the event the seller pays a commission under a listing agreement and the broker, with the consent of the buyer, is to receive any portion thereof, that portion will be credited against the buyer's financial obligations to the broker. So we're still trying to collect the money. And the broker shall use broker's best effort to cause the seller or the seller's agent to satisfy the buyer's obligation to the broker. So yes, ultimately the buyer is the one that's responsible for this, but again, we're trying to make more properties available to the buyer and make give the buyer the ability to pay more by having the seller pay the compensation. And, well, what if the seller won't pay? Well, in any purchase agreement, if the seller won't agree to pay, for example, closing costs, and we can't work it out, what happens? You find another property.
Yeah.
That's the way it works with any transaction. Well, what if my buyer has to pay a buyer agency fee and they're competing against other offers that are not asking for a buyer agency fee? Well, that means all those other buyers must be paying their agent directly, which I don't think is going to happen very frequently because they don't have the money in their pocket. They need it for down payment. So, in all likelihood, but in any case, if you're competing against a better offer, you're going to lose. I'm sorry, that's the way of the world. And the only thing that matters is, here's what Mr. and Mrs. Seller, pretty much what you will get compared to other offers as to what you will get. So don't think of it that you're always putting yourself at a disadvantage, because you can always be at a disadvantage because there could be better buyers out there.
Yeah.
Question. Brenda.
Brenda.
Well, if necessary, whatever. I mean, this has got no bearing on whether escalation clauses are.
Can you put in a purchase agreement that the buyer pay the buyer's fee?
You don't need to. It's no business of the seller what the buyer is paying unless the buyer's asking the seller to pay. Otherwise, I don't have to disclose that the buyer I'm paying an appraisal fee of $500. Got nothing to do with the seller. I'm
Brenda,
asking them.
I just want to be clear because maybe I misunderstood. Are you stating, like, let's say you have a great buyer and they're willing to pay McColly Real Estate and not ask the seller? That's what you're referring to? That, yeah.
There's multiple offers.
Okay. So when you bring your purchase agreement, you're not going to have included the fact that there's expectation for compensation. So yours is going to be cleaner than any, most of the rest of them because they're probably going to be asking for something. So yeah, that'll definitely set you ahead of the crowd. But I don't know that we need to use an escalation clause. Yeah. Yeah, you're right. And it all depends on the properties and.
It's anytime you're in a transaction where you're having to figure out how I'm going to be better than the other guy. Okay, then I've got to figure out ways to do that. This is no different. All right, then moving
Kelly
right
has a
on, we'll
que-
get
real
these
quick
again. So we're asking the seller to satisfy the buyer's obligation for compensation. And the commission is due, earned, and promptly if on line 27, the buyer or any other person acting for the buyer or the buyer's behalf acquires any real property. Again, it's exclusive agency agreement. So whether you or somebody acting on your behalf acquires property, you owe the fee, and buyer or any other person acting for the buyer or on the buyer's behalf acquires any real property of interest described herein, which was disclosed to the buyer. So here's our protection clause. If there's a property I told you about, or even showed you, but at least I told you about, you made aware of it, and you or somebody acting on your behalf buys it within, fill in number of days after the termination of this agreement, you still owe us a compensation. Now that one, minimum 6 months, I'd suggest a year. But
That makes
we don't
sense,
get
6 months or a year if you didn't hear.
If they sign another agreement, that's their problem.
Mhm. That's not for us to want. Can you tell them the line again on that, Tim?
This is line 29, 30, 31. That's our extension clause, the number of days for which you are protected if they go out and buy a house that you interested them in after the expiration that we had up on line 6. And then, pages 2, 3, and 4, again, this is all right out of the license law. There's nothing really
Shelley had a
negotiable.
quick question, Tim. Go ahead, Shelley.
So on your listing agreement, if you say that, the seller will compensate the buyer 2.5%. And then the buyer agreement is 2.5, you know, that the buyer, how does that work?
All right, how does it work? The question is, if I have a seller that says I'll offer 2.5%, and I have a buyer that's got a buyer agency agreement for 2.5%. In the purchase agreement, the buyer, because this is between the buyer and the seller, not between the agents and the seller. This is a contract between the buyer and the seller. And in the contract, the buyer says the seller will pay 2.5% towards buyer agency fee, because it's the seller that's paying it. Technically, on the closing statement, I probably shouldn't go here, but on the closing statement, there should be a credit from the seller to the buyer for the 2.5%. And then the buyer is charged 2.5% they're paying us.
Yeah.
That's the way it should be. We're going to teach the title companies about that, but that's okay. Not a big
It's going
deal.
to continue to be a work in progress. So keep it simple, everybody. That was a great example, Shelley. All that only happens because all the steps have been followed. If it's me bringing you the buyer, I have my buyer's exclusive agency agreement signed for 2.5, so I can show the house. I know that I'm going to be okay because my buyer will pay 2.5 if he decides to buy that house. She's offering it already, so then we're following the proper procedure on the contract. So you can see it's communication. I would have talked to Shelley. How's it look for any, commission and that kind of thing, so that you go in kind of knowing some of these things.
You have a buyer agency agreement for 3%. The seller's offering 2.5%. Okay? Buyer and seller agree that the seller will pay an additional 0.5% buyer agency fee over the 2.5%, or seller will pay 3% buyer agency fee, which is 0.5% more than they had offered, but bottom line, that's okay. So it's the buyer that is asking the seller that the seller will pay whatever it is we're asking the seller to pay towards the buyer agency fee.
Buyer agency fee. Keep it simple. That's different than closing cost credits. Lisa, okay. Lisa's got a quick question.
Just to help streamline this for some of our buyers who, if we put 3% in here and, they'll only pay us 2% and we're fine with that, and the buyer doesn't want to pay the other percent, can't we just, on all of these in the further conditions, state that the commission is negotiable upon?
But it says in the commission is negotiable. It says right in the contract.
Yeah, we don't want to say that again. We got to really keep, right? We talked about, we got to keep what we're adding to these.
Because it can't be a variable on this buyer agency agreement anyway,
That's what I'm
right?
saying. So
Correct.
there,
Got to be clear and specific as to what the compensation will be. Again, you can always go back at the end and say, okay, we'll amend that. Here's what we'll do.
You'll contact me and you'll say, Wendy, I'm sending you
But it
an
can't be on
amendment to,
here.
right. We can't be that flexible in there.
Yeah.
People have
Oh,
to know
go.
what's going on all along.
Okay, Robert, Mike. No, that's- Okay,
Question is, because of the environment we're in right now, where everything's multiple offer bid situation, and the only difference could be our commission, is there a way that we could have that not screw the deal over for our buyer? So let's say we're at 3% and someone else is at a lesser percent, and that few $100 makes the bid better for that buyer, that our buyer loses because we're charging too much for it.
again, it's no different than any other situation where we look at the net to the seller. I mean, what am I gonna say?
Your buyer can offer more, Steve.
To lower our commission if that was the deal.
Talk to the listing agent, as I know a lot of you do. Where do we stand? And, my buyer is really interested, so if necessary, I'll see what I can get worked out.
Yes.
What do we normally do when we have a situation? You talk to the listing agent and you tell them that, hey, my buyer really likes the property, so if we're kind of close, maybe there's something we can do.
It's coming down to the net amount of the seller.
Absolutely.
So
So
nothing is
I don't
changing,
need
just
anything in writing.
Steve?
There's nothing in writing that you need.
Sometimes the seller's gonna want to see something in writing saying, yes, Steve Krozak will take less commission.
Yeah, and that's where we have to be real picky, and I'm not trying to be picky, but I already foresee what some of these things are gonna happen. It's not gonna be Steve Krozak taking less, it's gonna be you calling me immediately saying, I'm in a multiple offer situation. Can we go from a 3 to a something? You have to do an amendment to that. It cannot be scratched out and nobody sign an initial. It has to be an amendment.
Amendment with the buyers too.
Yes, on the, right, to the buyer's exclusive agency agreement.
So we could-
But- But,
No, that's, I mean, no.
as soon as you start telling anybody that don't worry, it's negotiable, guess what they're gonna want?
Negotiate.
They're gonna want you to negotiate.
You know what I mean?
But the last thing I want to do is put in writing that, oh, don't worry, I'll negotiate, because they'll immediately want me to negotiate. All right, moving right along, because we got to get a couple things covered here. We're running out of time.
Yeah.
We're kind of at where we wanted. I'm sorry.
If the seller agreed to pay 3% to a buyer's agency, but we had a 2.5 with our buyer, they don't see that, they don't know that necessarily.
Correct.
So the 3% gets paid, and back to Jeff, I believe he alluded to the fact that 5% then goes to the buyer.
0.5%.
0.5%, 0.5.
0.5% goes to the buyer because we only had a buyer agreement for 2.5.
So
At
it's in
what
your
point
best
does
interest to
somebody
pay
see
higher.
that? Why don't we just take the 3? Does that make sense?
Because, I don't know, the DOJ police might be looking at you.
That might sense, and I hope you all did. So, okay, we gotta move on
Or
and
your
get this
buyer could say, well, wait a minute, how come you're getting 3? I thought we only had to get 2.5 here. So,
disclosed.
you know, we can't get into every.
Yep.
But, because actually, we don't have enough time to cover some of the things. I just wanted to give you an example.
Okay, just real quick.
So when we look at should a seller pay concessions, I'm the seller, why should I pay the buyer's fee? Let them pay their own fee. So I'm giving you examples here. So let's make some assumptions. Did you say with a first time buyer especially, the hard part is coming up with the down payment?
Yes.
Now, is it easy to save up? In this case, this buyer's got $25,000 in cash. Do you have a lot of first time buyers that don't have $25,000 in cash? Now you probably do, but this one does. And because they both work and they've got income, they can afford a payment, even at today's elevated interest rates. And do they want to buy a lesser home or do they want to buy more home?
Right.
They want to buy more stuff. They want to have a home that has more of the stuff that they want. So they can afford $300,000. I talked to the loan officer and he said, well, I'm going to need some concessions, but so the purchase price is $300,000. They're going to put 5% down. So that's $15,000. Their closing costs. Indiana is relatively cheap. But in Indiana, by the time you throw in the inspections and you throw in the home warranties or whatever, it's going to be about 2 to 5% of the purchase price. So I use 3%. So that's $9,000. And if they have to pay a 2.5% buyer agency fee, that's $7,500, which means they need $31,500, which means they're $6,500 short. And they don't have anywhere to get it. So how much are they going to pay the seller? They're not paying them anything. They can't buy that house. So what's the seller getting? Well, from that buyer, they're not getting anything. And that's the only buyer they've had so far. Uh-oh. I wish I'd have had a choice here, but I didn't. All right. So let's take the same buyer with $25,000 down. $25,000. The purchase price is $235,000. 5% down payments, $11,750. Closing costs, same 3%, $70.50. Agency fee, 2.5%, $58.75. Total, $24,675. So their buying power went from 300 down to 235 based upon the money they have. And they get to walk out with $325 for which they can go to dinner and buy a tank of gas.
Yeah.
And that's if the lender would let them because if they don't have any reserves.
Zero.
All right. Last one, purchase price $300,000, 5% down payment, closing cost 3%, agency fee 2.5%, but they're getting $9,000 of concessions. That means they only need $22,500, which leaves them $2,500 surplus. And the seller, we're now talking about the other transactional costs for the seller, is getting $291,000 on their $300,000 house. Mr. and Mrs. Seller, is that good for you? They have the same choice, they being the seller, as they do with any other offer to purchase. Bottom line, is that good for you? Does that work?
Does it work?
We've been on the market for 3 months. This is the first offer we've had. You want to take the chance that somebody's going to do better than this in the next 3 months? Or do you want to get settled, get on your way, get moved, and be done with it? I did suggest to you right up front that we were probably a little overly ambitious.
Yeah.
So it's no different than all the negotiations we do anyway. The last thing I gave you already touched on, no buyer agency relationships. So if there's a situation where you're talking to a buyer, like at an open house for your seller, you want to make sure the buyer understands that you are not at this point their agent. And again, you need to sharpen your skills because it's up to you to protect yourself. So let's, why is a buyer, should they buy from you as opposed to somebody else? How many buyers, same thing with sellers. When NAR does their survey of home buyers, how many agents did you work with before you bought the home? What do they usually say? Most of them. One. Why? Because the first time I meet with them, we build up trust, we build up rapport, I start doing things for them, and they feel comfortable with me, and they're more likely to stick with me. So that's why I said on the exclusive buyer agency, maybe it's a week, maybe it's 5 days, maybe it's 2 weeks, so we can kind of get to know each other. But once I start doing stuff for them and showing them all the stuff that's available through me, such as all the stuff on my website that's there, the fact that we can perhaps find properties before they actually come on the market through the coming to market program. So all these other things that we now have to educate them on to realize the benefits they will get from having us represent them and to sell their property, so we can then get into the longer term relationship. So I plan on spending a little bit more time on some of those things, but we're really up against the clock here.
Yep, just 2 quick things. What Jeff alluded to, I suggest that because this will not be on zip forms for a while, I'm gonna have a stack of sellers estimated net sheets in my briefcase or whatever, because you're gonna have multiple ones sometimes when you're trying to talk them into different scenarios with the commissions. Number 2, what was the second thing? I don't know.
As soon as we do see the new state buyer agency form, we will determine, maybe we can do a Zoom meeting, or again, depends upon the number of changes and what alternatives we have. My expectation is they'll come out with an exclusive agency, buyer agency, and a non-exclusive buyer agency agreement. That's what they have in Illinois.
Right.
I'm fully expecting that to happen in Indiana. And
Yep. Okay.
Just real quick, so what if I go on vacation for 2 weeks and Cheryl speaks to my buyers? Does she have to get the sign and send it out also?
If you're gonna have her write the purchase agreement, yeah, that's how I do it, because that's how I would do it, because if I'm entrusting an agent to do that for me, they're gonna be part of the transaction with me, and yes.
Okay.
And the thing I was trying to think of, I apologize. It's gonna be more important than ever. A lot of you are great at it, and I appreciate it. It's gonna be more important than ever, the timing and staying on top of your documentation. You have to get stuff signed. Please don't hold listings. Don't hold buyer's exclusive agency agreements. We have teams and some agents already using them. They get them to me like right away and I'll sign them. But we're really gonna have to stay on top of stuff being signed, because if you need to bring an offer and it's not signed, that's gonna be a problem. That makes sense?
if you have any questions, feel free to send me an email, send me a text, or send it to Wendy, and we
Happy
can
Tim and I,
discuss.
please. And we really, I can't tell you how much I appreciate the